Members of Parliament, support staff, radio listeners, TV viewers, all viewing this meeting via social media, members of the media, ladies and gentlemen, good morning, and welcome to this Central Committee meeting of Parliament. This is Central Committee meeting number 17 for today, Wednesday, May 27th. At this time, I want to give a special word of welcome to the Minister of Finance, Ms. Marinka Gums, and her support staff here with her this morning. We have established a quorum of 4 factions, and I invite you to stand for a moment of silence. Thank you. I have received notices of absence from the members of Parliament, De Wever and La Bega. Thus far, no notices of lateness. I'm just confirming that that is the case. Indeed, we have no notices of lateness at this time. I look to the Parliament members and ask if there are any notifications to be made. I see MP La Cruz wishing to do so. MP La Cruz, you have the floor.
A blessed morning, Madam Chair, Lady Griffier, Minister of Finance and her support staff, my fellow colleagues, and those watching and listening on social media. Madam Chair, Lady, for first a notification from MP Otley that he will be running somewhat late. And second, I'd like to send out condolences to the family of Gloria. Gloria was a person that anyone could count on in St. Peter's. She passed away yesterday in the Dominican Republic. Her daughter Luz, her grandchildren, and great-grandchildren, Carla, they were my students in school. So this is something that deeply touched me and touched the community in St. Peter's. So condolences on behalf of the United People's Party and also myself and my family. Thank you, Madam Chair, Lady.
Thank you, MP La Cruz. I wish to give an update with respect to some of the notices that we received. Thank you for the one regarding MP Otley, but we have also received notices of absence from the members Peterson and we thought Lewis, but he is still here. We thank him for making an extra effort to be here today. We have notices of lateness also from the members Kotai and Roseburg. So members, we continue with the agenda points for this meeting. And that is this is agenda point number 3 for this meeting. En het is de Ontwerplandsverordening houdende regels inzake het toezicht op effectenbemiddelaars en vermogensbeheerders. This is the Landsverordening, toezicht, effectenbemiddelaars en vermogensbeheerders. Members of Parliament, this is IS document number 065, dated the 2nd of October 2023, and it is draft National Ordinance number 171. Then we have agenda point number 4, and I'll be very specific about the agenda points before us because I have a proposal to make as we continue, but I'll come to that. Number 4 is de Ontwerplandsverordening houdende regels inzake het toezicht op betaaldienstverleners, de so-called Ontwerplandsverordening toezicht betaaldienstverleners. This is IS number 526, dated January the 7th of 2026, and it is draft National Ordinance number 187. As agenda point number 5, we have de Ontwerplandsverordening houdende regels inzake het toezicht op virtuele activa dienstverleners, de so-called Ontwerplandsverordening toezicht virtuele activa dienstverleners. This is draft National Ordinance number 188, and it is the IS document number 527, dated January the 7th. Number 6 on the agenda, point number 6 on the agenda, is again a draft national ordinance. For the members of the public, especially what I'm mentioning here, are draft national ordinances from the government and particularly from the Ministry of Finance. So I continue with the next draft national ordinance, which is the Ontwerplandsverordening, houdende regels, inzake oversight door de Centrale Bank van Curaçao and Sint Maarten. This is the so-called National Ordinance Oversight on Systems in the Payment and in the payment transportation, in the payment, yes, transport actually. This is the draft National Ordinance number 189, and it is IS 528 of the 7th of January 2026. We continue with agenda point number 7, another draft national ordinance, and this is the Ontwerplandsverordening houdende regels inzake de clearing en settlement systemen in de monetaire unie van Curaçao en Sint Maarten, the so-called Ontwerplandsverordening toezichtbeheerders FMI systemen. This is draft national ordinance 190, and it is the IS number 529, also dated the 7th of January of this year. We commenced the meeting of this Central Committee on Monday, March the 2nd, and we dealt with and handled agenda points 1 and 2, and these agenda points were closed. During agenda point number 3, the minister gave a presentation on the draft legislation on the agenda for this meeting, and the members were given the opportunity to pose questions to agenda point number 3, as well as agenda point number 4. Going over to agenda point number 3, this is an older one than the others, and thus it was since October the 2nd of 2023 that we received the draft national ordinance containing rules on the supervision of securities, intermediaries, and asset managers, so-called the National Ordinance on the Supervision of Securities, Intermediaries, and Asset Managers. As I mentioned, this document is registered as IS 065, and it is dated the 2nd of October 2023, and the draft national ordinance number is 171. Of course, members of parliament, ladies and gentlemen, these documents are available to members of parliament on the general teams, the parliament general teams. At this time, the minister has come to respond to the questions asked by members of parliament. So in a minute, I will give the floor to the minister. However, not before I ask the members and the factions here present to consider, as we deal with the other draft national ordinances on this agenda, that we look at these ordinances, so the ones that we have not yet started the handling of, and we give a certain date by which factions can present their questions in writing. And after that is done, we in a central committee meeting will ratify that report of questions by members of parliament, and then we send it on to the minister. Why? Because these matters are highly technical, and we encourage the factions, to deepen themselves into the matters and then prepare questions, and then the specific questions can be sent on to the minister. And so if the factions can agree with this, this is the way we will continue with the other draft national ordinances. And of course, once the report is ratified, so we'll just have a meeting to ratify all of the questions that we have accumulated. They go to the minister / the government, and then we'll get the responses in the same manner, finalize that report, and we would be ready for a public meeting for the handling of these matters. So with the factions here present, I look around, I see MP Lewis. Sorry. Oh, okay. Okay. Yes, so I'm asking if we can agree with that approach to these particular laws. It is something that we want to make part of our procedures going forward, but until we do that, if we can start with these laws here. Okay, without any objection, we continue, and also the minister would then understand how we plan to proceed. So I want to go back to, I mentioned that we now go over to agenda point number 3. We received that in October, and the minister has come prepared to respond to the questions asked. Minister Gums, again, good morning, welcome, and you have the floor.
Madam Chair Lady, honorable members of Parliament, esteemed support staff, members of the media, member and distinguished guests in the public tribune, radio and social media viewers, and residents of our beloved island, ladies and gentlemen, all under the sound of my voice, good morning and a blessed day to all. Today I return to Parliament to continue the discussion on the draft national ordinances previously presented during the Central Committee meeting of March 2nd, and to provide answers to the questions raised by the honourable members of Parliament. But before doing so, allow me, Madam Chair, through you, to make a few comments. These draft laws are important not only from a legal and regulatory perspective, but also for safeguarding Sint Maarten's financial stability, international reputation, and continued access to the international financial system. An important principle underlying these draft ordinances is the principle of uniformity within the monetary union, between Sint Maarten and Curaçao. As both countries share a joint central bank, it is essential that a harmonized supervisory framework exists to ensure effective oversight, consistent regulation, and equal standards across both jurisdictions. Maintaining this uniformity strengthens confidence in our financial system and protects the integrity, stability, and international credibility of the monetary union. The legislation before Parliament also forms part of Sint Maarten's commitment to comply with international standards concerning financial supervision, anti-money laundering measures, payment systems, and virtual asset services. Failure to implement these international standards carries significant risks, including reputational damage, increased international monitoring, pressure on correspondent banking relationships, and possible disruptions to international payment traffic. For a small and open economy such as Sint Maarten, maintaining confidence in our financial system and continued access to the international financial markets is of critical importance. And finally, through you, Madam Chair, before addressing the questions posed, I would first like to briefly respond to some concerns that have been raised regarding the definition of virtual asset service providers. In particular, questions were asked as to whether private individuals engaging in virtual asset transactions, such as the sale of cryptocurrency for personal purposes, would also fall under the licensing requirement. I would like to reassure the public and Parliament that this is not the intention of the draft legislation. While the definition has been drafted broadly in line with international standards, the licensing requirement applies only to activities carried out on a professional or commercial basis, and therefore targets companies and commercial services providers operating within the sector. Since that has now been clarified, I will now move on to respond to the various questions posed by the honorable MPs, starting with MP Labega, who asked, pertaining to the first law on the asset managers, he is not sure and would like to know, is Sint Maarten on the gray list, or are we close to the gray list? And if we aren't, how much time have we as a country known that this would be a possibility? So basically, are we on the gray list, or are we close to becoming on the gray list? Madam Chair, through you, Sint Maarten is currently not on the FATF gray list. However, we are under an enhanced follow-up process by the CFATF following the 2025 Mutual Evaluation Report. This means that shortcomings were identified in our AML-CFT framework and that improvements are expected within a defined time frame. The possibility of gray listing is therefore not new, nor did it arise overnight. Countries are generally made aware of these risks through the mutual evaluation and follow-up process, and Sint Maarten has been aware since the evaluation process intensified in 2024, and the report was adopted in 2025, that continued legislative and enforcement improvement would be necessary to mitigate the risk. Madam Chair, to be clear, Sint Maarten is not currently on the FATF gray list. However, the country is considered at risk if sufficient progress is not made in addressing the deficiencies identified by the CFATF. The concern is therefore not hypothetical, but also not immediate in the sense that a gray listing decision has already been taken. What is important at this stage is demonstrating political commitment, legislative progress, and effective implementation. The 5 draft national ordinances before Parliament form part of the broader measures aimed at strengthening Sint Maarten's regulatory and supervisory framework and reducing the risk of future gray listing. The core issue is ultimately one of protecting Sint Maarten's financial reputation, correspondent banking relationships, and international confidence in our financial system. I now move on to questions posed by MP Roseberg. Madam Chair, MP Roseberg made her question. If she looks at the laws, it is basically a copy of Curaçao's laws based on uniformity. MP Roseberg would like to have, if there is a clear difference to it, then maybe it can be highlighted what is the difference, because she hasn't seen it other than terminology. Madam Chair, through you, the Honourable MP is correct in observing that the legislation is largely aligned with that of Curaçao. This is intentional and stems from the principle of uniformity within the monetary union and the joint supervisory framework of the central bank. That said, the Sint Maarten versions are not a mere copy and paste exercise. The differences primarily reflect Sint Maarten's own constitutional and legal framework. For example, references have been adjusted to align with the Constitution of Sint Maarten, including provisions relating to independent administrative bodies, the publication of regulations in the National Gazette, and the recognition of national ordinances within our legal system. In addition, there are technical legal differences where Sint Maarten relies on its own legislation. A key example is the reference to Article 61A of the General National Ordinance on National Taxes, which serves as Sint Maarten's equivalent provision governing international tax information exchange. So while the framework remains harmonized for purposes of effective supervision and legal certainty within the monetary union, the legislation has been tailored where necessary to fit Sint Maarten's constitutional and legislative structure. Next question. What the MP would like clarification on is the issue of uniformity within the monetary union. If the intention is to maintain harmonized legislation between Curaçao and Sint Maarten, the MP does not fully understand why some of these laws date back to 2017 and were already approved in Curaçao, while others were only being introduced in 2025. The MP would therefore like to understand how this timing difference impacts the principle of uniformity and what approach will be taken moving forward. And through you, Madam Chair, I would like to thank the Honourable MP for the question, and I fully acknowledge the importance of uniformity within the monetary union. It is important to note that the oldest draft legislation, which was approved in Curaçao in 2017, was already submitted to Parliament in Sint Maarten in 2023. As such, the process toward alignment has been underway for some time. At the same time, I do understand the concern regarding the difference in timelines between legislation approved in different years. Moving forward, greater coordination, not only between governments, but also between both parliaments, would certainly strengthen consistency and improve the overall perception of uniformity within the monetary union. Next question. From the perspective of uniformity within the monetary union, the MP would like to understand what measures have been taken to ensure better synchronization between Curaçao and Sint Maarten, given that these draft laws are reportedly discussed jointly with Curaçao, the central bank, and the respective legal teams. It can create the perception that Sint Maarten is consistently lagging behind in the process. If these matters are being coordinated jointly at the technical level, why can they not also be coordinated more closely from a parliamentary and legislative agenda perspective? Through you, Madam Chair, I thank the Honourable MP for her question, and I do understand the concern regarding the timing and coordination of these draft laws within the monetary union. It is true that one of the draft laws entered into force in Curaçao several years ago and is only now before Parliament in Sint Maarten. At the same time, there are also areas where Sint Maarten has moved ahead more quickly on other legislative proposals. Recognizing the importance of alignment and uniformity, I took the decision to submit all draft laws together so that Parliament could consider them in a more coordinated manner. I also believe there is a value in continuing dialogue and coordination between all relevant stakeholders, including the governments, the central bank, legal teams, and both parliaments to further strengthen harmonization within the monetary union. Next question. If we are operating within the same monetary union, should we not explore a more coordinated approach to ensure the amendments or that amendments to these laws are introduced and addressed around the same time in both countries, so that implementation and application can also remain as uniform as possible? Through you, Madam Chair, I do believe that greater synchronization between both countries would be beneficial to the functioning of the monetary union and to maintaining legal uniformity. Going forward, as Minister of Finance, I intend to continue strengthening dialogue and coordination with my counterparts in Curaçao, the Central Bank, and the respective legal teams with the aim of encouraging earlier alignment and more parallel legislative timelines where possible. I also believe there is value in fostering greater engagement between both parliaments to support that process. I now move on to questions posed by MP York. MP York did not see any formal input or advice from the Bankers Association included with these draft legislation, particularly this specific draft law. Can the minister indicate whether the Bankers Association was consulted during the drafting process, and if not, why not? Additionally, would it still be possible to obtain and share their feedback with Parliament prior to the public meeting? Through you, Madam Chair, the 4 draft national ordinances were submitted in 2020 to various representative organizations for advice, including the International Banking Association and the Curaçao Bankers Association. The explanatory notes to the draft legislation also reflect that amendments were made based on the feedback received during that consultation process. While no specific consultation notes were shared with me as minister, it is clear that both the International and Curaçao Banking Association were consulted, particularly given that many banks operating within the monetary union have their headquarters or main offices in Curaçao. I am not entirely sure if this is where the Honourable MP was heading with the question, but I do agree that going forward, it would be beneficial to also formally engage the Sint Maarten Bankers Association so that local perspectives and input are equally reflected in the consultation process. Next question. Minister, do you stand behind all 5 laws as currently presented today in Parliament? Through you, Madam Chair, yes, I fully stand behind all 5 draft national ordinances as presented to Parliament. I personally submitted the last 4 draft laws to Parliament, and I also strongly support the oldest draft legislation because it promotes uniformity within the monetary union, has already entered into force in Curaçao, and supports the continued connection to international payment and security systems. Additionally, I believe it is important to uphold continuity and stability in government policy and financial governance. Next question. As it pertains to this particular law, the LTEV, I see a stamp, according to the MP, and he understood through the presentation that there is a slight sense of urgency to these proceedings as it pertains to these laws. The MP looked to this particular law and he sees a stamp in Parliament in 2023, and we're now in 2026. So his question, Madam Chair, through you, would be why the minister assuming office waited until now to bring the law and not in the year 2024 or 2025. Through you, Madam Chair, the LTEV was already submitted to Parliament in 2023 prior to my tenure as Minister of Finance. Since assuming office, my focus has been on ensuring broader coordination and alignment of the remaining draft national ordinances within the monetary union framework. As developments progressed, particularly in light of the increased focus surrounding the Mayville process, I took the decision to move forward with the remaining draft laws together rather than delaying the process any further. The intention was to ensure continued legislative progress, strengthen our regulatory framework, and support St. Maarten's international financial standing. I now move on to questions posed by MP Arian, who followed up from the question from MP York concerning the stamp from 2023. So it was brought by the previous administration. The MP agrees with the question from MP York. Does the government stand by all these legislations regarding all 5 laws, and does government take ownership of these laws? Through you, Madam Chair, yes, government does. From a constitutional perspective, the general principle is that legislative proposals submitted by a previous government are, in principle, continued by its successor. This principle safeguards continuity in the legislative process and promotes stability in governance. Accordingly, successive governments assume carriage of pending draft legislation, irrespective of the administration under which those proposals were originally submitted. At the same time, government always retains the authority to reconsider any draft law and, where deemed necessary, to expressly withdraw it. As these legislative proposals have not been withdrawn, it can therefore be confirmed that the government stands behind them and takes full responsibility for them. Next question. It is interesting that with some other draft laws, we are provided with the full legislative history and trajectory dating back several years, whereas with these draft laws, there appears to have been less background information provided. Could the minister elaborate on the broader context and development of these proposals? Through you, Madam Chair, unlike some other legislative proposals, my earlier presentation has focused primarily on the substantive goals of the draft law, of the drafts, rather than their full legislative history. That said, the underlying rationale and policy motivation are closely tied to the broader objective of ensuring that our jurisdiction remains a credible and reliable participant within the international financial community. In particular, the legislation is designed to align the domestic legal framework and internationally recognized recommendations, standards, and principles. A key driver in this respect is the need to comply with the recommendations issued by the FATF and the principles of financial market infrastructures developed under the auspices of the Bank for International Settlements and the International Organization of Securities Commissions. Adherence to these standards is widely regarded as essential for maintaining market integrity, safeguarding financial stability, and preserving access to international financial markets. Accordingly, while the historical trajectory of the drafts have not been elaborated upon in detail in my presentation, its content and justification are firmly rooted in these international obligations and the broader policy goal of maintaining St. Maarten's standing and reputation of the global level, at the global level, my apologies. Nevertheless, all relevant information can be found in the explanatory memorandum which accompanies each legislative proposal. Next question. When the MP looked at the law, then, and he's not too sure if the minister has access to conversations that were had. The MP knows that his then chief of staff and the central bank sat in different meetings pertaining to this. The idea then was, because of the urgency of the harmonization, to get in certain laws as quick as possible, and amendments would follow the next year, he believes. Madam Chair, through you, throughout the process, the minister's staff was consistently kept informed by the working group, which included representatives from the central bank as well as the legislative departments of both countries. This ensured that all relevant developments and considerations were communicated in a timely and structured manner. In addition, the minister personally received all pertinent information at the formal stages when the draft legislation was submitted to the Council of Advice and subsequently to Parliament. These moments provided a complete and consolidated overview of the proposals under consideration. Finally, the close involvement of the legislative departments of both countries throughout the drafting process provided an important safeguard for the legislative quality. Their joint review and input ensured the legal quality and consistency of the proposals, thereby minimizing the likelihood that further amendments would be required. Next question. This one was stated already in 2023, and all laws are exactly the same, so there are no amendments made. Through you, Madam Chair, I can confirm that that is correct. Next question. In looking at the situation in the U.S., and we are 3 years from when these laws were submitted, on a personal note, the MP Arian does not agree with certain aspects anymore in terms of us to follow international regulations and particular steps of what the central bank took above of what is required. Through you, Madam Chair, at the time these laws were drafted and reviewed, the intention was to ensure full compliance with applicable international standards and to safeguard financial stability. In some instances, this may indeed have resulted in a more conservative or comprehensive implementation than the minimum required. In particular, that is the case in the draft national ordinance on the supervision of payment service providers. That said, regulatory frameworks are not static. It is both appropriate and necessary to periodically reassess where the current approach remains proportionate, effective, and aligned with evolving international standards. So, I remain open to evaluating whether adjustments are justified while continuing to uphold our core commitments under international law and financial supervision standards. In other words, Madam Chair, the legislation was intentionally drafted to meet international standards and protect financial stability while still allowing room for future evaluation and adjustment where appropriate. Next question. The MP Arian said if he looks at the legislation from Aruba, Madam Chair, for example, Aruba did what the FATF needed. When he looks at the last 3 years, especially talking like cryptocurrency and virtual asset, etc., and how fast it has evolved in 2022 and 2023 by the previous government, a lot has been changed by then, a lot, and I do not see our current day reality in the law, and I also do not see future proofing in the law anymore. Madam Chair, through you, the primary objective of the present legislative framework is to ensure full compliance with the revised Recommendation 15 of the FATF, particularly in relation to virtual assets and virtual asset service providers. This recommendation requires jurisdictions to establish a comprehensive regulatory and supervisory regime that adequately addresses the risks associated with emerging technologies, including cryptocurrencies. While it is acknowledged that the rapid evolution of the virtual asset sector, especially throughout 2022 and 2023, but also last year, has introduced new challenges and developments, the core purpose of this legislation remains anchored in meeting international standards as set by the FATF. In this respect, the law is designed to provide a robust foundation for anti-money laundering and counter-terrorist financing compliance, rather than to exhaustively codify every technological advancement as it arises. Furthermore, I would like to point out that FATF standards are inherently risk-based and technologically neutral, allowing jurisdictions a degree of flexibility in implementation. Consequently, the draft legislation incorporates mechanisms that enable the bank to respond to ongoing developments within the virtual asset ecosystem without requiring constant statutory amendment. I would like to emphasize that the intent of the law is not to capture a static snapshot of the sector at a given moment in time, but rather to ensure alignment with evolving international obligations while maintaining sufficient adaptability to address future risks as they emerge, by granting the central bank the authority to regulate the sector by means of ordinances and supervision. In other words, Madam Chair, the legislation is intended to ensure that Sint Maarten remains compliant with international FATF standards relating to virtual assets and cryptocurrencies, while also giving the central bank sufficient flexibility and authority to regulate and supervise this rapidly evolving sector as new development risks emerge. Next question. MP Arian, Madam Chair, through you, think this law and also going back to the discussion we had on the basic banking law, we are given a little bit too much authority or power to the central bank, and we need to be able to allow more innovation. Madam Chair, through you, in response to the concern that this legislation may grant excessive authority to the central bank and potentially limit innovation, it is important to emphasize that the powers and responsibilities of the bank are not newly created nor expanded in the drafts under discussion. The authority of the central bank has already been clearly established in the Central Bank Statute as well as in the National Ordinance updating and harmonizing supervisory national ordinances of the Central Bank of Curaçao and Sint Maarten. These instruments provide a well-defined legal framework that governs the bank's mandates, its supervisory role, and its operational boundaries. These arrangements have been laid down in the Central Bank Statute, the mutual agreement between Sint Maarten and Curaçao, and a series of uniform national ordinances on banking supervision, ensuring consistency, legal certainty, and a balanced distribution of responsibilities. This framework reflects a deliberate and jointly agreed upon approach rather than an ad hoc concentration of power. At the same time, the existing legal structure does not preclude innovation. On the contrary, it provides a stable and predictable financial environment within which innovation can responsibly develop. Safeguards and regulatory clarity are essential to maintaining trust in the financial system while allowing new initiatives to emerge. Therefore, these drafts should not be seen as an expansion of authority, but as a continuation and implementation of already established agreements and legal principles. Through you, Madam Chair, in other words, these draft laws do not suddenly hand new powers to the central bank, but simply reinforce and modernize a supervisory framework that has long existed within the monetary union, while ensuring that innovation can continue in a responsible, credible, and internationally compliant manner. Next question. Again, if we look at the developments over the past 2 years, particularly in relation to AI and cryptocurrency, there is concern that overly restrictive regulation could potentially stifle innovation. Through you, Madam Chair, I do understand the concern regarding innovation, particularly in fast-evolving sectors such as AI and cryptocurrency. However, what are we suggesting, Madam Chair, that we simply leave these sectors entirely unregulated? The objective is not to stifle innovation, but to ensure that innovation develops within a safe, credible, and internationally compliant framework. The key is finding the right balance, because well-designed and proportionate regulation can actually support sustainable innovation by creating legal certainty, protecting consumers, and strengthening confidence in the financial system. Next question. In addition to that, the last time you as Chair Lady made remarks regarding the SER. Minister, do you not think we got, my apologies, Minister, I do not think we got your reply on those remarks as yet on a previous meeting on legislation, but the Chair made it clear. So again, do you believe these laws should have gone to the SER? Because I think the impact on the country in a similar fashion to the previous law. So will we submit these laws to the SER for their feedback? Because I asked some board members from the SER and they said they hope it will come to the SER. Through you, Madam Chair, the government has taken note of the question concerning the possible submission of the present legislative proposals to the Social Economic Council. The bills under consideration are intended to give effect to international recommendations and standards to which country Sint Maarten is bound. These obligations leave little to no margin for national policy discretion. In light of this statement, the government is of the opinion that seeking advice from the SER nor in an earlier nor in this instance would provide added value to the legislative process, as the substantive parameters of the legislation are, to a significant extent, predetermined by the international commitments. The government recognizes and fully endorses the advisory role of the SER in circumstances where meaningful national policy choices remain. Such circumstances, however, do not arise in the present case. Next question. The comments from the Council of Advice, does the Minister see herself in the comments from the Council of Advice? So does the Minister agree or disagree with the comments of the Council of Advice? Through you, Madam Chair, as can be read in the further report, I was able to concur with the majority of the recommendations of the Advisory Council. Likewise, the advice of the Advisory Council of Curaçao could also be incorporated into the two draft laws where Curaçao is ahead of Sint Maarten, namely the draft National Ordinance on the supervision of virtual asset service providers and the draft National Ordinance on the supervision of payment service providers. Madam Chair, I now move on to questions posed by MP Kotai. In terms of urgency and timing, Minister, can you clarify why the adoption of these uniform national ordinances is considered urgent at this time? What specific regional or international obligations make their implementation necessary for Sint Maarten at this present moment? Through you, Madam Chair, as I set out in my presentation on March 2nd, the draft national ordinances are intended to ensure that Sint Maarten can continue as a reliable participant in the international financial system. To that end, it is essential that Sint Maarten's legislation is aligned with international rules and standards. The National Ordinance on the Supervision of Securities Intermediaries and Asset Managers is a necessary precondition for membership in the International Organization of Securities Commissions. For the National Ordinance on the supervision of operators of financial market infrastructure systems and the National Ordinance on oversight of systems in the payments or securities sector, the applicable international standards are set out in the principles for financial market infrastructures. The PFMI were published in 2012 by the Committee on Payment and Settlement Systems of the Bank for International Settlements and the Technical Committee of the IOSCO. For the National Ordinance on the Supervision of Virtual Asset Service Providers, this concerns Recommendation 15 of the Financial Action Task Force. For the National Ordinance on the Supervision of Payment Service Providers, the applicable standards likewise relate to the FATF recommendations. However, even more important, it is my wish that the people of Sint Maarten will, in the future, be able to benefit from the convenient and affordable services that payment service providers can offer. As I aforementioned, answered to the Honorable MP Labega, the most urgent obligation is to prevent being grey-listed by the FATF. I refer to this exposition. Next question. Given that these legislative amendments are largely technical in nature, could you outline the tangible benefits that residents, consumers, and local businesses in Sint Maarten can expect to experience as a result of their adoption? Madam Chair, through you, the most tangible outcomes for the people of Sint Maarten are the protection of access to affordable and reliable international payment services, the reduction of risks associated with FATF grey listing, and the creation of a modern legal framework that can facilitate digital financial innovation. A direct and tangible result of this legislation should be the ability for more digital payment and financial service providers to become active in Sint Maarten, something the people of Sint Maarten have consistently been calling for. This would promote greater accessibility, efficiency, competition, and modernization within our financial sector. Next question. In terms of safeguards of fraud and abuse, how does these ordinances strengthen its regulatory framework in preventing financial fraud, money laundering, and other forms of financial abuse within our jurisdiction? Through you, Madam Chair, the ordinances significantly enhance the integrity and effectiveness of our financial supervision and oversight system by clearly designating the bank as the competent authority responsible for both the licensing and supervision of financial institutions. This dual mandate ensures a consistent and comprehensive approach to regulatory oversight. Through the licensing process, the bank applies stringent criteria, including fit and proper assessments, legal requirements as laid down in the National Ordinance on Combating Money Laundering and Terrorist Financing, and operational standards, thereby ensuring that only qualified and reliable entities are permitted to operate within the financial sector. In parallel, ongoing supervision enables continuous monitoring of compliance with applicable laws and regulations, particularly in the areas of anti-money laundering and the prevention of financial abuse, as established in the aforementioned National Ordinance on Combating Money Laundering and Terrorist Financing. Moreover, the strengthened framework equips the bank with adequate enforcement powers, allowing it to take timely and effective actions in cases of non-compliance or suspected misconduct. This includes the authority to impose sanctions, require corrective measures, or revoke licenses where necessary. Taken together, these provisions reinforce the preventive and corrective mechanisms within our financial system, reduce the risk of fraud and abuse, and contribute to maintaining confidence in the integrity of our jurisdiction. Through you, Madam Chair, these ordinances strengthen oversight of the financial sector by ensuring stricter supervision, stronger anti-money laundering safeguards, and greater enforcement powers to prevent fraud, abuse, and financial misconduct within our jurisdiction. Next question. Can you elaborate on how the proposed virtual asset legislation enhances Sint Maarten's competitiveness and credibility with the evolving digital and fintech economy? Through you, Madam Chair, the proposed virtual asset legislation should not be understood as primarily aimed at enhancing Sint Maarten's competitive position within the digital and fintech economy. Rather, its principal objective is to mitigate regulatory vulnerabilities by establishing a comprehensive supervisory framework for virtual asset service providers under the authority of the central bank. In the absence of such a statutory regime, Sint Maarten risks becoming an attractive jurisdiction for illicit or non-compliant actors seeking to exploit gaps in financial oversight and supervision. The introduction of clear licensing requirements, compliance obligations, and supervisory powers serves to prevent the relocation of criminal or otherwise undesirable service providers to Sint Maarten. In addition, it is important to note that the absence of a licensing and supervisory framework constitutes a practical barrier to legitimate market participation. Payment service providers and other regulated financial institutions are generally unwilling and, in many cases, unable to offer their services in jurisdictions where they cannot obtain a license or otherwise demonstrate that their activities are subject to adequate regulatory supervision. In their home jurisdictions, such entities are typically required to evidence to their competent supervisory authorities that they operate exclusively in markets where appropriate supervision is in place. Against this backdrop, the Landsverordening toezicht is, in essence, also intended to facilitate market access by first establishing a prohibition on operating without a license and subsequently creating a pathway to obtain such authorization under the supervision of the central bank. The legislation enables bona fide service providers to enter and operate within Sint Maarten and market in a compliant manner. Through you, Madam Chair, in other words, this legislation is primarily intended to protect Sint Maarten's financial system by preventing misuse of the jurisdiction for illegal financial activities, while ensuring that only properly licensed and supervised virtual asset service providers are permitted to operate within our market. Next question. What are the consequences of non-adoption of any of these uniform national ordinances? I repeat, what are the consequences of non-adoption? Through you, Madam Chair. As indicated earlier in my response, the principal risk is that Sint Maarten could face placement on the FATF gray list, together with the significant financial, economic, and reputational consequences that such a designation may entail. To put this into perspective, there are several very real and practical consequences that can directly affect our country and our people. Firstly, local banks may face increased scrutiny from international correspondent banks abroad. In practical terms, this could make international transactions slower, more expensive, or in some cases, even restricted. Ordinary citizens and businesses could experience delays when sending or receiving money internationally, while government itself could face higher costs in conducting financial transactions. Secondly, foreign investors and international businesses may become hesitant to do business with Sint Maarten. A gray listing creates the perception that a jurisdiction carries higher financial and compliance risks. This can negatively impact investor confidence, tourism-related investments, access to financing, and overall economic growth at a time when our country is actively working to strengthen and diversify its economy. Thirdly, and perhaps most importantly, the burden ultimately falls on the people of Sint Maarten. Increased compliance costs imposed on banks and businesses are often passed down to consumers through higher banking fees, stricter requirements to open accounts or obtain financing, and reduced access to financial services. In other words, the everyday citizen can end up paying the price for weaknesses within the regulatory framework. This is precisely why these legislative measures are so important. They are not merely technical or administrative in nature, but are fundamentally about protecting the financial stability, reputation, and economic future of Sint Maarten. I now move on to questions posed by MP York. Minister, through you, Madam Chair, there was an article recently, maybe a week or two to that date, about PayPal, Revolut, etc., and the digital opportunities that were not available for Sint Maarten at the time or would not be available to Sint Maarten at this time. How does this law expedite or help the endeavor moving forward? Through you, Madam Chair, The national ordinance creates market access for payment service providers. Without a license and supervision from the central bank, international payment service providers headquartered abroad, such as PayPal and Revolut, would not be willing to offer their services in Sint Maarten. So this draft is the first step. Next question. Is there anything in the law saying that the law was made before that discovery a couple weeks ago to that date? What is to be changed, amended, or adjusted within the law, saying what we know now in order to better the situation moving forward? Madam Chair, through you, absolutely. That is precisely the point. While Sint Maarten may be small in population, we should not underestimate our strategic position and transaction potential. Once this law is in place, we at least position ourselves to begin serious discussions with legitimate international payment providers such as PayPal, Revolut, or similar fintech companies. As Minister of Finance, I believe there are at least 3 strong arguments or proposals Sint Maarten can place on the table. Firstly, we are a de facto US dollar economy. While our legal currency is the Caribbean guilder, much of our tourism, commerce, and daily transactions are already conducted in US dollars. This makes Sint Maarten very different from many other small jurisdictions and potentially more attractive to international payment companies that already operate heavily in US dollar markets. Secondly, Sint Maarten is uniquely positioned between 2 major currency zones. We share an open border with the French side, which operates using the euro, while simultaneously functioning largely on US dollar on the Dutch side. That creates a natural bridge for cross-border digital payments, tourism spending, and international commerce in both currencies. Few jurisdictions in the Caribbean have that advantage. And thirdly, and perhaps most importantly, we should not focus only on the size of our population, but also on the volume and frequency of transactions. In Sint Maarten, welcomes millions of visitors annually through tourism, cruise passengers, online bookings, restaurants, car rentals, villas, excursions, and small business activity. The question therefore becomes not simply how many people live here, but rather how many transactions flow through this economy every single day. That changes the conversation entirely. So yes, Madam Chair, while this legislation alone will not automatically bring companies like PayPal or Revolut tomorrow, it creates the legal credibility and regulatory certainty necessary for those conversations to even begin seriously. I move on to questions posed by MP Arian. Regarding this legislation, or even the legislations in general, the discussions around that time, the central bank, we have to implement these laws, but do you have the capacity or resources to actually enable these laws? And at that time, the central bank said currently they were unable, but they were going to work towards that. Madam Chair, through you, the central bank has indicated that while some areas may require further strengthening of capacity and resources over time, these laws are not introducing entirely new responsibilities. In many instances, the bank is already carrying out forms of supervision and oversight in practice today. Additionally, several of these legislations are already implemented in Curaçao, which demonstrates that the framework is workable within our monetary union. Therefore, the legislation also serves to formalize, strengthen, and modernize existing supervisory practices while the bank continues building its capacity where necessary. Next question. We are 3 years removed from that. Through you, Madam Chair, the MP would like to ask the Minister, is the central bank capable of actually enforcing all legislations in front of us? This is not only his question, but also a concern from the Council of Advice at the time. Through you, Madam Chair, as outlined above, the bank already operates within an established framework and has necessary structures in place, while additional FTE will further support the effective execution of supervision, the bank is able to implement and enforce legislation once adopted. Next question. So we are 3 years removed. Curaçao already approved theirs. Are they able to effectively enforce the legislation? Through you, Madam Chair, Curaçao has approved the national ordinance on the supervision of virtual asset service providers and the national ordinance on the supervision of securities, intermediaries, and asset managers, the latter of which was formally adopted in 2017. The supervision of virtual asset service providers, including crypto-related services as regulated under the National Ordinance on the Supervision of Virtual Asset Service Providers, is currently still in an early stage of development. At present, supervisory efforts are primarily focused on ensuring compliance with licensing requirements, and the bank has been able to effectively enforce these requirements within this scope. I now move on to a question posed by MP Labega. Through you, Madam Chair, to the Minister pertaining to the last law with the payment systems. His question is, he knows that Revolut was on the Dutch side around 2021. According to him, he also had a Revolut card, and then around 18 months after that, he doesn't want to be quoted exactly on the time frame, and it was revoked on the Dutch side. And the MP would like to know why that was done, because according to the MP, we don't have the laws in place, but they came in. So they come in without knowing that, or something happened during that time. Madam Chair, through you, my understanding is that Revolut may have initially allowed limited access to persons on Sint Maarten through its broader international platform, even in the absence of a specific local legal framework. However, over time, companies such as Revolut continuously reassess jurisdictions based on regulatory certainty, compliance requirements, market viability, and supervisory frameworks. At this time, there is no indication that their services were revoked due to one single incident. Rather, the absence of a clear licensing and supervisory framework likely made long-term operations within Sint Maarten less feasible from a regulatory and commercial perspective. This is precisely why these legislations are important. They create the legal certainty and regulatory structure that legitimate international payment providers generally require before seriously considering market participation or expansion within Sint Maarten. Through you, Madam Chair, hence why it is so important that Sint Maarten establishes these laws and regulatory framework now, because without the proper legal and supervisory structure in place, legitimate international payment service providers are less likely to view Sint Maarten as a stable and viable market for long-term participation. Next question. The MP was under the impression maybe the banking system didn't like them here because obviously when they do peer-to-peer transactions, there would be a possibility for the banks to lose transaction fees. Madam Chair, through you, that perception is understandable, but it does not fully reflect the situation. The limited presence of international payment service providers is primarily linked to the absence, until recently, of a clear licensing and supervisory framework, combined with the relatively small size of the market, which may affect commercial viability. Next question. Can you give clarity on when they left approximately and what was the reason for them leaving? Through you, Madam Chair, we do not have confirmation on when they exited Sint Maarten. However, based on available insights, their absence appears to be primarily driven by considerations of commercial viability and absence of regulatory framework. I now move on to questions posed by MP Roseberg. Building on the questions previously raised.
Minister?
Yeah?
If I may interrupt you just for a second and just for the recording of what we're doing, you have gone over to the questions on agenda point number 4?
Yes.
Yes.
Yes. Yes.
Yes, just wanted to establish that. Thank
Okay.
you. We adjourn for a minute, yes. Minister, After all of that information, it might be a good idea also taking into consideration my question to you about agenda point number 4. So let's just adjourn for 4 or 5 minutes. Meeting adjourned for 5 minutes. of Parliament, ladies and gentlemen, Minister of Finance and your support staff, the support staff of Parliament here with us. Welcome back as we continue with this Central Committee meeting of Parliament, handling several, especially central bank related draft laws as presented to Parliament by the government of Sint Maarten. The Minister is actually, and this is for the notification of the members of Parliament especially, the Minister continued with giving answers to agenda point number 4. However, when that is done, there are some more, according to our records, there are some more questions regarding agenda point number 4. The Minister is going to continue with those, and then we will go back to 3 and see whether there are any outstanding questions, but that in any case, we can close off that agenda point in Central Committee. So I just wanted to establish how we will proceed. And after that, we come back to 4, time permitting, etc. And then we'll go over to what we discussed earlier this morning about the continuation of the meeting on the other draft laws before us. So, Minister, you may continue from where you were at before the adjournment. Minister Marinka Gums.
Thank you, Madam Chair. I now proceed with the questions by MP Roseberg. Building on the questions previously raised regarding the recent discussion surrounding companies such as Revolut and PayPal, there appears to be a perception that Sint Maarten is often following developments rather than leading them, particularly when Curaçao updates legislation first and Sint Maarten subsequently adopts similar measures. Given the pace at which financial technology evolves, what concrete steps are being taken to ensure that Sint Maarten becomes more proactive and forward-looking in modernizing its financial legislation and positioning itself competitively within the digital financial sector? Madam Chair, through you, I do not believe that the legislative process for uniform draft laws within the monetary union should be viewed as a competition between the countries or institutions involved. Ideally, these processes should move in parallel, including the drafting phase, legislative review, advice from the respective councils of advice, and ultimately parliamentary approval in both countries. It is also important to clarify that Sint Maarten is not merely following Curaçao. As indicated earlier, the decision was made to submit all 4 draft laws to Parliament simultaneously. As a result, Sint Maarten is in fact ahead of Curaçao on 2 of the draft legislations, while Curaçao has progressed further on the other 2. Therefore, the legislative development has been balanced and evolving at different speeds across the various proposals rather than being one-sided. Next question, because if we are updating a law of 2017 or updating the current laws that need to be updated, how are we making sure we are not wasting the legal resources? We don't have to update a law that needs to be updated again within a few months or is already outdated once it is finally into effect. Madam Chair, through you, I do not expect that this legislative proposal will need to be amended in the near future as the international standards underlying it remain unchanged. Next question in regards to the SER, is there plans to go through that trajectory? Madam Chair, through you, as previously clarified, the bills under consideration are intended to give effect to international recommendations and standards to which country Sint Maarten is bound. These obligations leave little to no margin for national policy discretion. In light of this statement, the government is of the opinion that seeking advice from the SER, nor in an earlier nor in this instance, would provide added value to the legislative process, as the substantive parameters of the legislation are to a significant effect predetermined by international commitments. The government recognizes and fully endorses the advisory role of the SER in circumstances where meaningful national policy choices remain. Such circumstances, however, do not arise in the present case. In addition, the Department of Legal Affairs and Legislation did not advise for these national ordinances to be advised on by the SER. Next question. What I wanted to know, what the MP wanted to know is if there's also plans to go just to make sure that the Council of Advice is thinking in this current state, if that is also a plan to get a current update, as some of these laws went through the Council of Advice years ago, and maybe the position from the Council of Advice has changed. So just to make sure that those adopted or adapted legal pointers are still legally sound nowadays or from long time before, and maybe they think different about this. Is this the plan of the minister? Through you, Madam Chair, I recognize the importance of ensuring that legislation is based on sound and consistent legal advice. All drafts were previously submitted to the Council of Advice, and the advice received have been duly incorporated. I am not planning to seek renewed advice from the Council of Advice. It would be highly unusual to do so where the substances of the legislative proposals, such as the international standards, principles, and recommendations, have remained unchanged, apart from amendments made in response to the Council's earlier advice. I therefore consider that the legal basis of each draft law remains sufficiently safeguarded. I now move on to questions posed by MP York. MP York had a question with regard to Revolut and PayPal subject. Madam Chair, through you to the minister, he remembers when the article came out. If he was not mistaken, it is an article of the central bank basically saying that Revolut and PayPal were not interested in doing business on Sint Maarten. The MP does not remember any official communication from my person. Can I attest that that was really what was stated in the meeting? And lastly, was the minister a part of that meeting? Through you, Madam Chair, no, I was not in attendance at that meeting. However, based on the article published in the media in March of this year, the indication was that international digital payment platforms are not currently planning to enter the market, primarily due to the limited economic scale and certain regulatory challenges. In essence, the concern raised was that the market is presently viewed as not being commercially viable, particularly when weighing the relatively small size of the economy against the costs associated with compliance, licensing, and regulatory obligations. Next question. For the record, the same question as asked pertaining to the first law as it pertains to the Bankers Association. The Honorable MP would like to know if the Bankers Association's notes were received by my person. Through you, Madam Chair, as previously stated, the 4 draft national ordinances were submitted in 2020 to various representative organizations for advice, including the International Banking Association and the Curaçao Banking Association. The explanatory notes to the draft legislation also reflect that amendments were made based on the feedback received from the consultation process. While no specific consultation notes were shared with me as minister, it is clear that both the International and Curaçao Banking Association were consulted, particularly given the many banks operating within the monetary union have their headquarters main office in Curaçao. I am not entirely sure, again, if this is where the Honorable MP was heading with his question, but I do agree, Madam Chair, going forward, it would be beneficial to also formally engage the Sint Maarten Bankers Association so that local perspectives and input are equally reflected in the consultation process. I move on to questions posed by MP Arian. Through you, Madam Chair, during the discussions surrounding the basic banking account legislation, the minister indicated that additional legislation would be forthcoming to address some of the concerns the MP attempted to address through his proposed amendment. Having reviewed the presentation before us on that day, the MP would like clarification as to which of these draft laws specifically address those concerns. More specifically, the concern raised was that individuals should be able to conduct digitally the same types of banking and payment transactions that they are able to conduct physically or in person. Can the minister indicate where and how this principle is addressed within the proposed legislation? Through you, Madam Chair, this concern is addressed primarily within the National Ordinance on Oversight of Systems in the Payments, or securities sector and the National Ordinance on the Supervision of Payment Service Providers. Through you, Madam Chair, this concern is addressed primarily within the National Ordinance on Oversight of Systems and in the Payments of Securities sector and the National Ordinance on the Supervision of Payment Service Providers. These legislations provide the central bank with authority to ensure fair and equal access to financial services, including payment services for all users. In practical terms, this means that holders of basic payment accounts should not be placed at a disadvantage and should have reasonable access to both digital and physical banking services, such as online banking, mobile banking, branch services, and payment facilities. In addition, the legislation requires payment service providers to act honestly, fairly, and professionally in the interest of their clients. The central bank will have the supervisory authority to monitor and enforce these standards, thereby promoting financial inclusion, consumer protection, and equal treatment across the financial sector. Next question. In addition to that, also regarding the Second Amendment about Revolut and PayPal, wherein these legislations now allow the opportunity for the central bank and the banks to create their own version of PayPal or Revolut for the kingdom at the very least. Through you, Madam Chair, the National Ordinance on the Supervision of Payment Service Providers, Landsverordening, toezicht, betaaldienstverleners, is open to all market participants. It does not single out or restrict specific entities, but rather establishes a framework under which any qualified institution may develop and offer payment solutions. In this case, the legislation creates a level playing field as long as the applicable licensing and regulatory requirements are met. All entities have the opportunity to design and implement their own payment systems and services. I now move on to questions posed by MP Duran. Through you, Madam Chair, if members of Parliament in St. Maarten were to propose amendments to one of these draft laws, how would that affect the harmonization of the uniform legislation within the monetary union with Curaçao? While both countries share the same monetary union, St. Maarten and Curaçao are autonomous countries and may at times have different policy views or developmental priorities. In practice, how much flexibility does St. Maarten have to amend these laws while still maintaining alignment within the monetary union framework? Additionally, were these draft laws submitted to Parliament exactly in line with the versions approved or proposed in Curaçao, or were these adjustments already made beforehand to reflect St. Maarten's specific circumstances? Madam Chair, through you, these uniform laws are unique in nature because while they are enacted as national laws within each country, they are also intended to function in harmony within the monetary union between St. Maarten and Curaçao. As such, both countries must continuously coordinate and align throughout the legislative process. In practice, if one parliament were to amend a draft law differently from the other, this could impact the uniformity and functioning of the monetary union and would therefore require consultation and coordination between countries. At present, there is no fully established constitutional procedure for how such differences would ultimately be resolved, as this remains a developing area within our constitutional framework. With respect to the draft laws before Parliament, these were largely prepared in close coordination with Curaçao and the Central Bank, although the legislative progress has not moved at the exact same pace in both countries. Going forward, I believe it would be beneficial for both countries to establish a clearer joint procedural framework for handling these types of uniform legislations, including the treatment of possible amendments. I now move on to questions posed by MP Otley. How do we ensure that St. Maarten is not simply following Curaçao when it comes to these legislations, but is also taking into account our own norms, realities, and vision for national development. Considering that some of these draft laws date back to 2023 and that the financial sector evolves rapidly, were any updates or adjustments made to reflect Sint Maarten's current situation, and was the advice of the SER sought given the magnitude of these legislations? Madam Chair, through you, I do understand the sentiments expressed by the honourable member. There is sometimes a perception that Sint Maarten is merely following Curaçao, and I believe it is important to state clearly that Sint Maarten is an autonomous country with its own vision, priorities, and policy considerations. However, we must also recognize the reality that in 2010, both countries consciously chose to enter into a monetary union together. By doing so, certain aspects of financial and monetary legislation, particularly those connected to the central bank and the stability of the monetary system, must remain aligned. This is therefore not simply about following Curaçao, but also ensuring the proper functioning, credibility, and stability of the monetary union that both countries agreed to uphold. With respect to the SER, I certainly appreciate the importance of stakeholder input. However, Madam Chair, I would also respectfully ask, how would referring these matters now to the SER when these legislations are fundamentally driven by international standards, compliance obligations, and monetary union requirements make the process appear less aligned with Curaçao? The reality is that many of these obligations stem from international financial standards that both countries are jointly required to implement in order to remain or maintain access to the international financial system and protect the integrity of our financial sector. I move on to a question posed by MP Roseberg, again concerning Sint Maarten following Curaçao, what the MP would love to see. Curaçao has to follow us. As we say, we're standing for Sint Maarten. Harmonization needs to take place. Next to the SER, you have the Council of Advice. The MP would humbly want to know if the Council of Advice is still of the same opinion. These laws are not effective nowadays. We have to be effective with our legislative capacity. Through you, Madam Chair, it should be noted that from a constitutional and administrative perspective, it would be highly unusual for the government to seek advice twice on the same draft legislative proposal, except in circumstances where the substance of the proposal has undergone significant and material amendment. The established practical reflects, the established practice reflects both respect for the advisory process and the need for procedural efficiency and legal certainty. Furthermore, I do not expect that the Council of Advice would arrive at a materially different opinion in the absence of such substantive changes. The international standards, recommendations, and underlying principles upon which the draft legislation is based have remained unchanged since the Council entered its earlier advice. In these circumstances, in my opinion, there is no indication that a renewed request for advice would yield a different assessment. In addition, please be aware, as explained earlier, that Sint Maarten is not following Curaçao. Now, all 4 draft laws are submitted to Parliament simultaneously. Sint Maarten is several years ahead of Curaçao on 2, while Curaçao has been several years ahead on the remaining 2. I now move on to questions posed by MP La Cruz. Madam Chair, MP La Cruz was somewhat confused, and that is why he's going to ask, or why he asked this question to the Minister through you, Madam Chair, who created these laws. Who created these laws? Was this a combination between Sint Maarten and Curaçao in the past? Was it solely Curaçao? Was it the Central Bank of Curaçao and Sint Maarten? Who created these laws? Because the narrative that the MP is hearing, these were just done by Curaçao alone, and Sint Maarten had no part in it, so that it is somewhat confusing to the Honourable MP. Madam Chair, through you, it should be noted that the earliest draft legislative proposal, namely the National Ordinance on the Supervision of Securities Intermediaries and Asset Managers, was prepared by the bank and subsequently reviewed only by the legislation department in Curaçao. So, without the involvement of the legislation department of Sint Maarten, my predecessor in office was not satisfied with that process. A different approach was therefore adopted in respect of the 4 subsequent draft legislative proposals. On the initiative of the bank, an experienced legislative counsel was engaged who operates independently of both Sint Maarten and Curaçao. The bank acted as commissioning authority in this regard, given that it possesses the most comprehensive expertise concerning the international context underpinning these 4 national ordinances. A dedicated working group was established comprising subject matter experts within the bank alongside the external legislative counsel. For each of the 4 draft proposals, it was a guiding principle that all substantive issues would be addressed in parallel consultation with the directorates of legislation of both Sint Maarten and Curaçao, thereby ensuring alignment, consistency, and legal quality throughout the drafting process. Next question. The laws that have passed in Curaçao, are they now active, and how does that work, seeing that we have one central bank? Through you, Madam Chair, the oldest law entered into force in Curaçao July 17, 2017. As of 2018, the law has been fully applied and enforced by the central bank. There was no urgent need to quickly introduce the law in Sint Maarten as well, because there were no independent asset managers or intermediaries active in our country at that time. The Landsverordening toezicht entered into Curaçao into force July 1st last year. The bank has nearly finished preparing fully applicability and enforcement. Next question. The MP doesn't understand that either, because if it were laws that would govern the central bank, then one passed, they would pass for both countries, so he's a bit confused on how that works. Through you, Madam Chair, I appreciate the question raised, as it touches on the important balance between maintaining our autonomy as a country while also fulfilling the obligations that come with the monetary union. As I indicated earlier in response to Member of Parliament Duran, any mutual arrangement relating to the central bank or the monetary union is, in essence, an agreement between Sint Maarten and Curaçao, which requires approval by both parliaments before it can take effect. Naturally, because it concerns a shared monetary framework, the intention is that the arrangement functions equally and consistently in both countries. At the same time, the implementing legislation itself is adopted in the form of national ordinance within each country. The structure was intentionally chosen in 2010 because both Sint Maarten and Curaçao wished to maintain their autonomy as separate countries within the kingdom. As such, legislation passed in one country does not automatically apply in the other. That being said, I personally support greater synchronization and coordination between both countries, particularly when it comes to the adoption and implementation of uniform legislation tied to the monetary union. While this has not always occurred perfectly since 2010, it is my hope that moving forward, all relevant authorities in both countries continue working toward a more aligned and coordinated legislative process. Next question. And when and if we do pass these laws, are we able to bring amendments to it? And then what will take place with the laws that are governing Curaçao? Because again, we are talking about one central bank. It is somehow confusing, and I would like to suggest to the Minister to make this clear first. Madam Chair, through you, as explained earlier, a uniform national ordinance is enacted as domestic legislation in the form of national law. However, all authorities in both countries involved in the legislative process must be aware at every stage that they need to align the content with the same authorities in the other country involved. Because of the uniformity, a high degree of legislative alignment between Curaçao and Sint Maarten is necessary, particularly in light of the monetary union. Madam Chair, that brings me to the end of the questions and answers posed. I would like to thank you for the opportunity to address and respond to these questions raised by the honorable members of Parliament. With that, I conclude my responses for the questions and answer session while remaining available should there be any additional questions or clarifications required by the honorable members of Parliament. Thank you.
Minister Gomes, thank you for those responses to the questions posed by members of Parliament in the first session of this Central Committee meeting on the relevant agenda points, namely 3 and 4. At this time, members of Parliament, I want to go back to agenda point number 3 and ask members if there are any follow-up questions on agenda point number 3. Just to make sure, that is the draft national ordinance on the supervision of securities intermediaries and asset managers. That's agenda point number 3. We've had the questions. We got the answers to that. If not, we'll consider this agenda point sufficiently handled. Okay, I see that we can agree and move forward. That would then bring me to agenda point number 4, on which questions were asked as well. And I'm just going to pull up the English part of, or the English translation of that particular one. And that would be under agenda point number 4, the Ontwerplandsverordening is the draft national ordinance containing rules on the supervision of payment service providers. National ordinance on the supervision of payment service providers. Just to remind you, members, this document is IS 526 and draft national ordinance number 187, if you needed to look it up once again. So I ask on agenda point number 4 whether the yes, okay, I see some at this MP Jansen-Webster would like. MP Jansen-Webster, you have, just let me for the sequence of things. No, first I'll go back and make sure that we conclude 3 correctly, and that will be that the report on 3 will officially be sent to the government and the minister. That's agenda point number 3. Then we go to 4, and as I was saying, we have gotten answers to questions which were posed on number 4, draft, or agenda point number 4, the draft ordinance, and I see MP Veronica Jansen-Webster. On that, you have a question, right, MP Jansen? MP Jansen, you have the floor.
Thank you, Madam Chair, and good morning to my colleagues and to everyone listening. My question is regarding a question that was asked by MP Arian, and it was answered by the minister, through you, Madam Chair, regarding which of the laws will now be the ones used for the payments such as Revolut, etc. And the minister explained the oversight of systems, and then there were 2 others, and I was not able to write down which those 2 others were. And then additionally, I had a question about if these 3 laws that she mentioned, if those are some of those listed here that we have in our agenda today. Because here we have it in Dutch, and the minister answered them in English. So I wanted to know if they were the ones that we have coming up that we said that we would discuss as factions. Thank you, Madam Chair.
Thank you, MP Jansen, for that question, clarification on the matters that we are discussing. I now give the floor to MP Arian on agenda point number 4. MP Arian.
Thank you, Madam Chair. So my question was actually on that same topic. The minister mentioned responding to me, my question was basically on my amendment that I brought forward in a previous meeting, and that one was not supported. But in that one, I specifically was bringing an amendment, and if you watch how the world is operating, and that was my question and my narrative in the previous meeting, actually, that we can't just adopt and say, okay, this is what the central bank wants. Things are moving way too fast to say, hey, we're going to do this sometime in the future. We don't have that kind of time in the future. We absolutely don't. And we have to be able to say, no, this is what we want for Sint Maarten going forward. I don't really care where Curaçao is on and so forth. I don't. I care about where we are. And right now, my amendment, what I want is to say, whatever we can do physically, as a human being, physically, I want the bank to establish that that should be able to be done virtually, digitally. It cannot be that Parliament is on we just started an official work group for going digital and AI as a Parliament. We're going this route. The government wants to establish this. And now we're saying we're going to keep the bank in 2010, right? So this is not enough for me, because in your response to you, Madam Chair, and the minister's response is the bank will monitor, the bank will do oversight. I'm not asking for that. I'm asking for, this is what you have to do. We have the bank, the commercial banks of Sint Maarten, have to ensure that everything that we could do physically should be able to execute digitally and virtually. In essence, I shouldn't have to leave my house to do basic operations at all. And that's not the answer that I got. So and the answer that I got is telling me that's not going to happen. And when we look at, for example, legislation in the Netherlands, because a lot of times we bring up the Netherlands, etc. So in the Netherlands in the past, for example, it was, even for ATMs, it was specific on where you could have gone and you had to use your Rabo PIN by a Rabo bank if you don't want to be charged any fees. Today in the Netherlands, you could go by any ATM and the similar fees or zero fees. For example, again, in the Netherlands, for example, they had to establish a law that says when you PIN, there's no transactions. That wasn't done just by banks and you have tried, right? Putting articles in the paper and saying, no, please comply. But what has that done? Nothing, right? So the banks, the stores still charge the extra costs and so forth, or they say, we're not going to accept this because you don't buy enough food or you don't buy enough of our product. So even though the government says, hey, I want you to comply, banks put out and say, no, this is not what the rules are. What happens? Nothing happens. And in the Netherlands, what they did was say, hey, this is a law. This is it. This is flat out. You don't get charged a penny more for pinning. So you as a company now have to establish your prices with whatever the extra costs are. So all costs are then built into your product or your service, but not that you're going to deny individuals. I went to a restaurant once and they tell me, I already got my food. And I said, I don't have cash. So now we're in a stalemate, because I said, I'm not leaving here to get cash. So I'm going to either leave my food or you have to take back the food. Because I didn't want to, and so no, buy a drink. I said, I don't want a drink. I just want to pay my card and leave. So the answers, and I want to be very clear, I would like for the ministry to own the questions themselves. So if the government does not agree with me, that's a different thing. So first, I would like, before I get a response, does the government agree with my statements or my questions? So if the government owns this, then the questions go to the bank, and then you have to get the proper answers from the bank on, hey, if you can't do it here, where exactly will this be established? Because I want to establish first, does Sint Maarten, does the government agree that this is where we want to head to? And then the second point about Revolut and PayPal, it has already been established that they're not going to be here. Right? And your answers also, we don't have enough framework. Okay, fine. And in my other amendment that was shut down or not voted on, right, I said, okay, if we don't have the environment for Revolut or PayPal or any of these international services to work at Sint Maarten, then we have to create our own. So the answer for the bank saying, oh, we create enough room. No, because if there was enough room, we would have had already. There's enough companies that came to St. Maarten while I was minister saying, I want to operate to St. Maarten, but we can't get connected. So the answer is not sufficient. And I can tell you why, because every company that wants to participate in the digital payment platform atmosphere needs to be able to operate good, needs to be able to connect to the commercial bank's APIs. So if you don't have access to the commercial bank APIs, right, you're not going to get an instant transaction. There's companies in Trinidad, Barbados, there's enough regional companies that do this already, but they don't have access because the bank's saying, hey, we want certain guardrails, and we don't trust these companies, and the company's saying, hey, we have our security. So the bank, which I'm referring to as the central bank, they have to establish the guardrails and say, hey, this is what we want. What do we need to be able to have these payment systems in St. Maarten? So again, I want to know from the government if they agree with my questions. Does the government own and believe that we deserve to have a payment platform in St. Maarten? If that's the case, and we cannot have PayPal and Revolut among others, then wouldn't it be an idea for then the central bank to create the parameters of which we can operate in to create our own, or create the proper parameters that allows all the other regional companies to properly participate in a proper payment system for St. Maarten. It cannot just be the central bank going to monitor and have oversight and no, 'cause it doesn't work now. It's like saying, and a lot of so-called capitalists say, no, the market will regulate itself, but it hasn't regulated itself. Otherwise, we would have had it already. Thank you, Madam Chair.
Thank you, MP Irian. Minister, you have heard some additional questions regarding agenda point number 4 in particular. I want to ask the members if they would agree with the questions as we do have. Okay, I'll finish my question to the members and then allow MP La Cruz, of course, to make his statement or ask additional questions. But I was going to ask, following MP La Cruz and any other member who has something else to ask regarding regarding agenda point number 4, if we could agree that those questions will be answered by the minister in the report from the government, which of course we shall receive before the handling in a public meeting of these draft laws. And I'm trying to be as efficient as we can on these matters before us so that they're not like stretched out over a very long period of time. And by the time we get to the last one, then we probably might need changes to the draft laws for all that I know. So just in order to avoid that is why I put a question forward. MP La Cruz, your questions on agenda point number 4. Follow-up questions on agenda point number 4. MP La Cruz.
Thank you, Madam Chair Lady. Madam Chair Lady, during the break, I had a short discussion with the minister concerning a document that I received while in Curaçao. The minister said that she received that document also and that she will definitely be discussing this in her next meeting with the Central Bank in Curaçao. Hence, the 12 questions that I have, I am not going to ask them because they are related to that document and the working of that document. So I'll await the minister to come back after that and let us know how that went. And then, if needed, I will still ask those questions. Thank you, Madam Chair Lady.
Thank you, MP La Cruz. That is also noted. And if there are no objections to my proposal about the questions just asked, the follow-up questions just asked on agenda point number 4, then then I want to add to those questions a question to the minister that I informally ask, and I would like the minister to take it along, and that one too can be part of the questions to be answered in the report by the minister, and that is regarding the house bank, as we call it. And just recently, it was announced that the government of Curaçao appointed Banco de Caribe as their house bank. If we can receive an update about our house bank and how far or close we are to the period to look at the house bank. So that's my question. But also interesting in the context of a law passed by Parliament here and on Curaçao regarding the basic bank account. And in the selection of Banco de Caribe as the house bank for Curaçao, it was mentioned by a government representative that with that bank being the house bank for Curaçao, different type of businesses, including, for example, lottery businesses, would be allowed to open a bank account. Considering the whole process that we went through to come to a law on a basic bank account, my question to the minister is, if that relationship regarding a house bank and the authority of a house bank to basically say who can and who cannot have a bank account, how that reflects to the whole process of we having to go through in order to have a law on the basic bank account. So in essence, can the house bank of the government of Sint Maarten decide that which institutions and businesses can or cannot have a bank account, even with the law currently in place, is my question to be taken along. In the answering by the minister. And then the members of parliament, can we agree that the follow-up questions asked on agenda point number 4 will be answered by the minister in the report from the government in response to us? Then a report of this agenda point in this meeting will be sent to the government, including the request that we receive the answers posed today. The answers to the questions posed today by in the report, the written report by the minister. That's agenda point number 4. Members of Parliament, as we discussed at the start of this meeting, and I put forward the proposals and which did not receive any objections at the time, and that on the next agenda points, so agenda point number 5, National Ordinance on the Supervision of Virtual Asset Service Providers. Number 6, National Ordinance on Oversight of Systems in the Payment or Securities Settlement Systems. Agenda point number 7, which was the National Ordinance on the Supervision of Operators of FMI Systems. And so now I'm going to ask if the factions and members here present can agree that the questions on these 3 agenda points be submitted by June 11th. If that's workable, if that is workable, so those be sent in. And then a central committee meeting will be called in order to ratify those questions, that the reporting of those questions together. And then of course, the final report will be submitted to the minister, because we need to follow that written and official process, because we're dealing with draft national laws. But again, in order to get it clear, because if we if we look at the questions that were posed, for example, and then the minister having to come in here and for us to understand where she's at to repeat the questions and the answers given, if we can just have it in writing, we submit them in writing, we get them in writing, they're there for the records and the archives. So if we can, so then again, the eindverslag, the final report, will be submitted to the Minister of Finance, the government officially of, the government, and then we await to receive the nood naar aanleiding van het eindverslag, and then we go over to the handling of the public meeting of these matters in the public meeting. Before I kind of conclude this, I give MP Iran the floor.
Thank you, Madam Chair. So I could, I understand the reasoning. But to clarify, in this instance, then there will be no sort of room for clarifications based on the questions we send in writing, I'm assuming.
What can happen in the ratification of those questions, if you have one to be added, your faction, then definitely that can be stated, and that will be then adjusted in the ratification of the report with those questions to the government, if that is clear.
Okay.
So then, members, that is how we will proceed on the 3 ordinances that I just mentioned. And then this central committee meeting can be closed and a new one will be called just to ratify when we get in the questions from the members by that date. And then we ratify those questions to go in a formal reporting to the Minister of Finance / the government of St. Maarten. It is a process, members, that as we, with our secretariat, look at a more efficient way of dealing with draft national ordinances and just making sure that the reports that need to be compiled to go to government and the reporting that we get back from the government, that is part of the process. So with this, members of Parliament, I want to thank you for your participation. To the Minister and her support staff, thank you, Minister, for the responses and the recording of the remaining questions on agenda point number 4 to come back in your report, and then we will proceed, members, and if there is any reason why you can't meet the deadline of June 11th as a faction, because that's the way that the reporting is done anyhow. Dus de fractie van de DP heeft de volgende vraag, and that's the way we do the report, etc. for all factions, of course. And then, so if you cannot meet that deadline, please indicate it to the Secretariat that we can then maybe to kind of adjust our scheduling somewhat. Members, thank you. Minister, thank you. Support staffs, thank you. And I hereby close this Central Committee meeting of Parliament. Meeting closed.